The second phase of this is set out, there are two more questions that I would like the panel to address, but I want to do two things. First of all is to tell all of the panel members if they have other reminiscences or what my hope had been that by talking about this, it would bring back memories in all of our, to all of us. And so if there are those who would like to reflect upon what other peoples have said, if they would please do that as well. And then the two questions is, did your perspective on stream access change or evolve during the process of working on it? And what lessons did you learn that you would think future stakeholders should bring to mind when working on natural resource legislation? So Tom is just coming back down, and we're going to let him answer that after a bit. But Stan, why don't you go ahead?
Sure. So I guess the question as to whether my perspective changed over the course of this, and it did in this way. During the litigation, I sort of had two tasks that I was sort of charged with dealing with in the litigation. One was to support the coalition's position on stream access, and the second was to rebut legal arguments that were made by the landowners about issues of taking. I mean, one of their sort of central themes was that this stream access law was going to result in unconstitutional takings of land and real property. And so my perspective of the landowner interest was largely molded by arguing against their sort of property rights constitutional claims. And so as I came out of the litigation, I had, I guess you'd say, a very sort of legalistic 10,000 foot view of what the landowner interests were. And I didn't think they were very legitimate at all. I mean, I think, and we were correct about that their legal arguments were not valid. Once we started into the legislative process, though, I had to change my focus, because now it was for us to think in terms of what are the legitimate concerns of landowners with regard to this law. And as you might guess from the previous discussion, there was a lot of white noise about what the concerns of the landowners were. When you got to the grassroots level in some of those hearings, it got a little bit crazy at times. But for me, I think the saving grace was that I was spending a fair amount of time talking to Ron Waterman about this stuff. And Ron, being Ron, was able to sort of distill the real legitimate issues for landowners into something that was concise and coherent in a way that as we came out of that process, I came to appreciate that at ground level, at grassroots level, I guess you could say, landowners had some really legitimate concerns. And so for me, the overriding lesson of that was that when you get into these issues of landowner versus recreationist, or even in some resource issues, you need to sort of look beyond the big themes of what people are throwing out in terms of their position and look to the sort of practical things on the ground. And that has informed the rest of my work since then in water rights and stream restoration and other issues. So there you have it.
Tom, do you want, we were talking about either, perspectives, did your perspectives of stream access change or evolve, or what key lessons have you learned to tell future stakeholders, or as I was so abrupt in cutting you off a little bit before the break, if you'd like to continue with your recollections there, the floor is yours.
Okay, Tom Buney again. I got a few more things I was rattling on there, and I didn't realize the time was up. But when we hired Jim Getz, and we met with him down in Three Forks, Montana, a number of times. Jerry and I went down there a number of times. I met with Jim, and he's the one that decided on. There were three rivers we were looking at: the Dearborn, the Smith River, and the Beaverhead. And he finally felt that the Dearborn was the best because Michael Kern had a lot of money. He was wealthy, and he was a cantankerous guy. He was kicking guys off the river and people off the river. It was a navigable stream. They floated logs down and everything. So anyway, we took on the Dearborn, and then after we had filed suit on the Dearborn and ready to go to district court, the guys from Dillon came in. Monty Hankinson, he would have been here today, but he couldn't make it. Monty was an outfitter, he still is down there in Dillon, and he was having trouble with Michael Curran on the Beaverhead, floating down the river.
It was Hildreth.
What's that?
Hildreth on the Beaverhead. Hildreth on the Beaverhead.
I'm sorry, Hildreth, okay. With Lowell Hildreth was kicking outfitters off the river, demanding a fee to float the river. Well, Monty told him, go to hell. He was said, I ain't going to pay you any money. So Curran, he lowered his bridge and put panels under it. And when we had a float underneath there, it made it where somebody was going to get hurt. I floated one day down there and took my 2 clients, let them walk around, and then I went underneath and hit one of those panels and dumped my boat. Luckily, Monty was down the river, and he picked all my stuff up that was floating down. That's besides the point. But anyway, a couple more things. So Jim charged us a half rate fee. And how are we going to raise the money? Jerry and I thought, oh my God, we got 2 lawsuits now, and we're going to have to raise a lot of money. So we went to, first of all, we started with memberships for $5. And then we went to pins for $10. And then trout prints with Harvey Eckert from Butte was an artist, and he drew brook trout, rainbow cutthroat, and rainbow brown brook trout and cutthroat, I guess. And we sold those prints, and he did it for nothing for us. We sold those prints all around the country. Just mailed them out, and for $20. So anyway, went over to Helen. There's a House Bill 888. It was going to be passed by both of them, and then Michael Curran come in with Galt and got the bill killed and went to Supreme Court. Jerry and I went over to Helena and watched the Supreme Court hearing. It was an amazing thing. The 7 justices were up there, and Jim answered all their questions. Well, then we waited for a couple of weeks or so for a ruling, and then the ruling came out. It was just not navigable stream. It was all water in Montana, all streams. And I was elated. I'm still elated what happened. I can't believe that, and the landowners were, they were good. And a lot of them were worried about, we're taken away from them. But the water, we weren't taken away. They had the water rights, and they used the water forever, the irrigation and crops and everything else. So, they come around, and a lot of them, to this day, got a little bit of animosity still. And so anyway, that's how everything started, I guess. Okay.
Al, you have the floor.
Al Harper again. First of all, state administration policy following House Bill 265 has not always been the same, and it has varied with when certain governors are in the office. And I think panelists may address some of that a little bit later. But in my time here, I'd just like to read a little bit about what happened during the hearings. The State Judiciary Committee was chaired by Joe Mazurik. And this is a lesson in legislative patience. Legislative patience and listening and letting the people of the state have their say is so vitally important for people's support of legislation. Mazurik's committee had 260 individuals and businesses testify in front of them. And opponents, of course, railed against the bill. And one person said, codification of this taking in legislation is only exonerating the thief. Another stated, this bill could well establish a socialistic trend, the opposite of what made America the greatest nation on earth. But the very last statement of the day, which carried the day, was from the Montana Cattlemen's Association member, said, months of study and negotiation have accomplished what years of conflict will not. So Bob Ream, Missoula's own Bob Ream, who was an expert canoeist, closed the hearing on that bill with these words: you are now up the creek with a paddle. House Bill 265 is your canoe or vessel. I hope the committee will dip its paddle carefully Watch out for rocks. Don't get out of the boat until safely ashore, unless they can walk on water. 14 separate votes were taken on that bill and amendments before it passed out to the Senate floor.
Jim?
With the question, my perspective on stream access didn't really change during the session because as a director of the department, I had that primary responsibility in this matter as opposed to myself as an individual. So I never made my mind up at any point in time prior to the session that this is what should be done. As I mentioned earlier, I was primarily looking for a direction, legislative direction on how to proceed on the matter. With the key lessons, I had the privilege to serve in the State House of Representatives for 2 sessions and was Governor Judge's legislative assistant for 3 sessions, and then 4 sessions as the director of the department. And perhaps if my time was 2 or 3 hours, I could go into some suggestions, because each session has its own dynamics. Al mentioned the House session where there were 50 members from each party, which is a dynamic, very unique, and I don't know if it's ever happened since then. But so there is no overriding rule, and I would say that the key thing, and it's something you can't plan for, but it's having the right people in the right place at the right time. And if you don't have that, your chances of succeeding are lessened, and the effort is usually much, much more difficult. And my observation from the 8-5 session is 2 of the really right people in the right place at the right time were Mary Wright, representing the Crowd Unlimited, and Ron Waterman representing the myriad of groups that he was representing. But I would have point out one piece of advice to people going into the legislature to pass a bill. You have to understand that the legislature is situated on the west wing, the 2nd floor of the Capitol, and there's 2 houses, the House and the Senate. And on the House side, there's a drinking fountain that the House members use, and it's full of pure Montana water. That's water we're all proud of, very nourishing. And then on the Senate side, there's another fountain. For decades, there have been analysis done on the water coming out of that Senate fountain, and nobody can figure out what it is, because the senators take this beautiful House legislation, and invariably, it doesn't matter what the issue is, they screw it up. So you want to start your bills in the House and get that momentum, because when you go to the Senate side, where they've been drinking out of that fountain, you might be in trouble.
Bruce, you get the next word.
Well, really, the water that they were drinking, I would like to say, was probably the fountain of youth. It was well done. But I would point out to you this, that that was such a good bill that came over from the House. I don't know why you didn't pass the thing, why you had to go to a subcommittee. You had to control, the Democrats were in control, you just blew it through. Before I go any further with my comments, I'd like to thank Jacqueline Van, who was a gal that I had the opportunity and the pleasure to work with on this memory book. And I met with her one time in Missoula, and she did a great job. She's a junior in law school. She's going to be graduating another year. She's available, I think, for work, and so grab her if you can. I also would like to thank my co-senator over here, Tom Tao, because in the file analysis, this bill wouldn't have been here like that if it wasn't for Tom. Tom was a great guy to work with. We were good friends. We battled like mad during sessions, but we never were personal. We never made it personal, and oftentimes we would go out after these sessions, especially this thing, and have a couple of beers and.
No, I don't drink.
No, well, I knew there was something wrong about you right there. Other than that, you're okay, but we got along just fine. But this is a CLE course, and so I guess I would point out from the standpoint of being an attorney. I was the only attorney on the Republican side of the Senate deal, and so I was putting myself in a position when at that time, when I was asked to represent Jack Galt, who was vehemently opposed to this thing, and we're both in the Judiciary Committee, and I finally agreed to do that. And once you do that, and once you find yourself in a position that you've agreed to take on a case for somebody, you go into it and you look at it, like I did, and I realized, number one, this bill is going to pass. It is going to pass. There's no way in the world I'm going to drive a stake through its heart. No way. And it had a good purpose, and I wasn't interested in doing that. But what you do, that you represent the person that you represent, in that case, Jack Galt and some of the opponents, to the best of your ability, and you work hard to make sure that the issues that you see needed to be worked on and refined a little bit come to the attention of the whole subcommittee and try to get something done together. And I think that's what we did in this subcommittee. And I mentioned this before. When you have a subcommittee like that, that's their role in the legislature. What it is today, I don't know. But in those days, we could sit down, Republicans and Democrats, we'd have our own different ideas. But by the end of the day, we walked out, we were friends, and we could go afterwards and sort of laugh about what the press came up with, which was clearly opposite of anything that we did, and going down the line. And so, the one last thing about who I'd represent, what you would represent, anyway, I would say, the best person to get would be, of course, Getz and Juan Waterman. You get those two, you've got it made. Okay, that's all.
I want to echo exactly what Senator Crippen just said, because that's really, I think, important. I think it's really significant that this bill came in from the House, and part of the legislative process is to go through those people who have objections and see what we can do. And are they valid or not? And if they are valid, what can we do about it? And I think it was with that spirit that we took on the bill. Bruce says, well, why didn't you just, the bill is going to pass. Why did you waste time with this? Why didn't you just kick it on through? We didn't do that because that's not the legislative process. The legislative process was working, and I think it worked very well. And it's because people like Bruce and I can get together, we can go battle each other on the floor, but as Bruce says, we have great respect for each other. We always have, and I think always will, because we believe in them, and I want to hear what he has to say before I vote. I want to hear his arguments. I want to hear what these other people are saying, and then if there's an issue and it makes sense, let's see what we can do about it. And that was the spirit with which we took on this bill. And I really think that we did a good job in doing that. I want to comment, I was reading through, this is the conference committee report, the minutes of the conference committee. At the end, the issue of lakes, and I mentioned that before. It was in and out, and in and out. Well, the final version, it was out. Jack Galt in the conference committee made the motion to put the lakes back in, and that failed. And then the Representative Ream moved that the House accede to all the remaining Senate amendments. There were a couple that had already been voted on, but most of the Senate amendments, and that motion passed, and that went on through. The Senate did make an impact on the bill, and I think that was good.
Tony Shonin again from Butte. as time goes on, you have a lot more respect for the compromises that were made by all the groups that were involved in the stream access. And I respect it even more. We just finished a lawsuit with a very wealthy person. I think he had 7 or 8 billion. James Cox Kennedy on Ruby River. And before that, thanks to the Montana Trout Unlimited on the Mitchell Slough, they came in and helped us on that. That was Huey Lewis and wealthy people. They wanted to tweak the stream access law, and it's not tweakable. It stood every test of time. The other group, Mountain States Legal Foundation, that was James Watt group, and Gail Norton out of Denver, Colorado, were representing 3 or 4 people down around Ennis and in there, and it's withstood every test. And actually, the Mountain States Legal Foundation took it all the way back to the U.S. Supreme Court, and they refused to hear it because it was too well founded in states' rights. And so, I mean, it's the battle with Kennedy. It just finished here a couple of years ago, and hopefully this year we got our accesses in at the Sailor Lane Bridge, which was a big point of contention. And after 14 years, maybe I'll be able to put my boat in and float that Ruby River again.
Mary?
Again, Mary Wright. Did my perspective on stream access change? No, it did not. I thought we went in with a good product and we came out with a good product, but it's also because my client's position didn't change, and I was representing them after all. As for what future stakeholders should keep in mind on natural resource litigation, I'm afraid I don't have much to add there, because I've spent the 30 years since stream access mostly working for a small state agency that reports to a bipartisan committee of the legislature. And it wouldn't have been too prudent for me to keep advocating, except as part of my job. So I guess I would counsel people to please be as fortunate as we were in 1985 with the coalition that we had. Thank you.
Stuart Doggett again. Did my perspective, did it evolve? No, I became a believer early on. I was young, I was impressionable, but I guess one thing that did evolve was my appreciation for the law. It wasn't too long after the session that they sent me down by myself to talk to a group of ranchers and members in the Ruby Valley. And of course, I was on the agenda. One of my other tasks was to talk about public lands and state grazing districts. That was part of my job with the stock growers. But the conversation ensued where people made some strong allegations about the bill and just, pretty wild comments about it, what it contained, and all this thing it was going to create. Unfortunately, I had prepared myself, had the bill, and was able at the time to lay it on an overhead and kind of say, the law doesn't say that. Here, I was able to, let's read the words together. And again, I'm not an attorney, and the people in the room are not attorneys either, but the power of the words in the bill made a difference. And again, I get back to what I previously referred to about the Supreme Court decision. It's hard for non-lawyers to read those and make sense of it. And so the bill helped frame the issue, and people like myself that advocated for it could defend the bill, could explain to people about it. They might not like it, but the point was, ranchers wanted to say they had no control over access, and again, I was able to point out, even as a young lobbyist, here the language in the law that actually does give you the power to control that situation. Real quickly, key lessons that I learned as a young lobbyist, I can continue to learn today or try to emulate, is that if you have a controversial issue or you're framing a bill, get it out early, because then you can kind of neutralize potential opponents. But in other instances, you can get those that are going to be in opposition to the bill to cough up all the reasons they oppose it early on, and then you could prepare a rebuttal for it. And I saw Ron Waterman do that effectively for the stock growers. So I like to get things out early, and you could kind of neutralize folks, but also get again some information of why they oppose it and then counter it. So thank you.
Tony Shonen from Missoula. My perspective did not shift on House Bill 265. I was surprised, however. I thought it was a slam dunk. It was a little more complicated. But to Ron's point earlier about the power of coalitions, and in my opinion, that's really the lesson learned. I am not an attorney. I work with a lot of attorneys. My day job consists primarily of natural resource legislation, not here in the state, but in Washington, D.C. And my one piece of advice would be that successful natural resource legislation does not come from conflict and polarization. It comes from cooperation, collaboration, consensus. And I think that's what you saw, an example with House Bill 265. Every issue has its stakeholders, and some people are on extreme sides, and sometimes those people can be helpful because they allow those of us in the middle of the road to come to successful resolution. At the end of the day, I think House Bill 265 was a primary example of a good group of people who came together and did the right thing. Thank you.
I can only say ditto to all of those things. I think building coalitions, being sensitive and aware of where the various parties are and trying to resolve and address those, I think is critical to doing anything in natural resource legislation. I think that you have to look at alliances. And I always maintain that there is a natural alliance between landowners and sportsmen. That the people who use the land on a regular basis to raise crops, to raise animals, want habitat and want the same resources that fishers and hunters want to be able to pursue big game and other opportunities. And look for those coalitions, look for the naturalness of those coalitions. Now, we have about 15 minutes, and what I'd like to do is throw it open for questions. I think Michelle's got a microphone, and I'm going to invite anybody who either has comments or questions, and I'll try and push the question to the right person to answer it. And Michelle, so anybody, please. And please give us your name.
Thank you. I'm Bert Lundler, and in the early 80s, I was working for the Falls Tribune. I received a call one morning. A woman told me that her raft had just been run over in the Borough Pit. I weigh 287 by Michael Curran. So I congratulate Jim Getz on picking the right opponent. I forget where this particular incident occurred in relation to the passage of the bill we've been discussing today. But unfortunately for Michael Curran, in the party of floaters was a plaintiff's attorney, Howard Strout. So he can't be here today, but he did sue Michael Curran after this. And to my best of my recollection, I think the suit was settled. And my suspicion is that it was settled for a lot more than the price of the replacement. Thank you.
Don Murray, a lawyer from the Flathead, and I wonder if anyone has second thoughts about excluding lakes. Are the legal principles that apply to public access to lake shores the same? Do those rights remain unresolved? And do you think it would be possible to resolve them with legislation in the future?
Tom?
Yeah, let me start on that. I'm not sure I can answer all of that, but just to give you a little bit of background in what we did talk about with lakes. I think many of the members of the Judiciary Committee thought, and especially the subcommittee, thought that that's exactly right. lakes is a very big part of this, and that should be included. But maybe we're taking on too much. And in fact, I was told at one point, point blank, if you put lakes in this bill, it'll kill it. And I'm not sure whether that's true or not, but I didn't want to take a chance. In fact, we talked about, even before that came up, the possibility that what we're really talking about is 3 classes of water. The non-navigable water, the navigable water, and lakes. And they each one are different. And there's no reason why the same principles shouldn't apply, but there are also specific problems with the lake. There's a bigger problem with the lake when you're starting to talk about, are you going to allow hiking and swimming and maybe even hunting or some other recreational activity within 300 feet of a dwelling that's on a lake. Is that any different than it is on a river? In some cases, yes, and in some cases, no. So it's a different issue, and we said, hey, we've got enough to deal with here. Let's leave that for the next time. And as to what should happen, let somebody else address that.
Yeah, I agree with Tom on that, but you know, there are some lakes. We have the Harrison Lake over in southwest Montana that basically, I think Senator Debbie Barrett turned that over to the irrigators. So basically, you know, there's no ownership by the public in that lake. And I think the same thing's going to happen with the Ruby Reservoir down there. I'm just talking about the lakes that I'm familiar with. So, you know, you're going to run into a can of worms on some of these that are basically the early irrigators put in so much money. It might have only been 40 cents on the dollar that they put in so much money to have those dams built, like the Ruby Reservoir and so on and so forth. So that would be some consideration, I would think, on that.
Just briefly, you have to look at the politics of the situation. At that time, when the lakes were put back in, a number of people that in the legislature, Bob Brown including one of them, who was a very influential senator, was opposed to the bill. When they took it out, amazingly, and he was my roommate, he was in favor of the bill. Yeah, I know. That's put ground glass in his beer. But nonetheless, you have to look at the politics, because if you start putting lakes in it, I'm not saying you shouldn't, but you're going to have a whole different class of opponents up there. And, so that's fine, but there's a lot of legislators that are going to listen to those people. And you're going to have to really be careful and do it right, because you're going to have a lot of opposition from those type of people. And it's going to be very difficult, I think.
I learned an adage a long time ago. You can eat an elephant, you just can't eat it all at one time. There's another question.
My name is Mark Hogginus, and I just have a question. Outside of the extraordinary influence that the director and chief legal official like Park had, what other influence did the governor's office have on the legislation? What is it for or against it?
None.
He left it alone. I didn't see the governor's office one way or another in legislation. When he signed the legislation, however, he gave a cautionary word to me, and he said, "I think what you've done is just pulled the scab off of a wound that was healing from the Supreme Court cases." And he said, "Back off a bit and let that scab grow again." Others.
Thank you. Zach Brown, I serve in the legislature now, and as a fisherman, I've inherited the legacy of all of your work, so thank you for that. I have 2 questions. The first one might be easy because no one may want to or have an answer to it, but I'm wondering if anyone has a perspective on what happened in Colorado over the same time period that pushed their stream access laws in a totally different direction than what we have in Montana. I'm curious if anybody has a perspective there. As we know, Colorado can fence off sections of river and just have a totally different legal framework. And my second question is, are there any issues facing Montana today that can, I guess, that we can learn from the process that you all undertook on this issue? Are there any issues that are reminiscent of the state that you all had? Thank you.
Yeah, Tony Shonen again. You know, the big problem that we're going to face here in Montana, right along with Colorado and Wyoming, wealth. These people have found Montana. They've established large homes on the Colorado River and the Platte River, and some of these main rivers in Wyoming and Colorado. And the way their early legislation was, and it wasn't like our 1972 Constitution. The landowners owned to the middle of the river. So what it is, then you have to get permission from every landowner on both sides of the river, and you know that's totally never going to happen. And it could still happen here in Montana. James Cox Kennedy, when he first came into Montana, said, yeah, I agree, I understand. I bought the land along the Ruby River. Remember, he has 7 or 8 billion. Most of us don't make anything like that. But then he tried to overturn it. But my whole answer to all of that is just extreme wealth and selfishness by these wealthy people.
Yeah. Somebody ought to tell us what did happen in Colorado.
Well, I don't know that anyone is, I'm certainly not familiar with all of what happened in Colorado, but I do know a couple of differences. They have different language in their constitution. They have different court decisions than we do. I think with respect to what the future holds, we're going to address that later in the conference this afternoon. So I would defer until this afternoon to maybe have that discussion. So are there other questions? Over here.
I'm just wondering if anyone would like to tackle what kinds of ways do you see the public trust doctrine being used today to address natural resource concerns? I know that's pretty wide open, so maybe I should narrow it to water-related concerns, perhaps fishing-related concerns.
Public trust doctrine. Okay, Stan will try it.
So that's Ada Montague, by the way. She's incognito, didn't want to identify herself. So I'll address a little bit of that from the water rights standpoint, because that's where my brain lives these days. Back in about the time that our stream access decisions were coming out, and I think Jim Getz referred to the Mono Lake decision, which really was a water rights decision in California that basically enshrined the idea that if you're going to tinker with water rights, you're going to have to deal with the public trust doctrine. And so for a long time, when I started working for Trout Unlimited after I left Fish, Wildlife, and Parks, the issue came up a number of times about, well, shouldn't we sort of push the idea of public trust doctrine for in-stream flows? And so that idea has been around for a long time, and I don't pretend to know whether we could pull that off in Montana or not. But what I do understand from spending time talking to lawyers in California who have been involved in this is that as a practical matter, that decision in the Mono Lake case ended up having relatively limited impact on how people treated sort of public trust values in water rights transactions and in water rights changes and new water rights in California. So part of the question I think that anybody will have to answer if they decide to pursue that is whether, first of all, I think you have to you have to assume that if you're going to pursue the idea that public trust doctrine ought to apply in a big way to water rights, that you're buying a big fight, either judicially or legislatively. And so you have to do some calculus about whether the grief to fund factor is going to make it worth the trouble. And so, part of my view is now colored by the fact that I work with irrigators daily to get them to voluntarily lease water rights to Trout Unlimited. And one of the things I've come to appreciate is that there are a lot of other sort of habitat issues that usually attend a dry or stressed stream bed that also need the voluntary cooperation of those landowners. And so, as a practical matter, there's a lot of sort of social issues you have to try to deal with if you're going to go down that route of some sort of public trust application to water rights, and at least from my lens, in-stream flow.
Tom.
Could I just add, I would echo what Stan just said. I think that that's very significant because the in-stream water is a very big issue that we've just barely scratched the surface on. By the way, the legislature has not been totally silent on this issue. I will remind you that we do have the Yellowstone River and the allocation of water in the Yellowstone River, and never got past that, I guess, in the legislature. But there is an in-stream allocation that was critical as the beginning point in the Yellowstone River, and that's law today. I think it's a huge area that's likely to be litigated and discussed and legislated for a long, long time to come. And in addition to that, I want to say something also, and again, I'm echoing what most everybody else here has said, but I want to make it clear that what we're here today is because of Jim Getz and because of what he did and what he got the Supreme Court to do. That public trust concept is huge. It's huge. And when you look at that and all the ramifications that has, not just on water, but on recreation uses. What is recreation use? How have we defined that? How far does that go? There's a lot of things that have to be discussed and worked out and determined in the future. And I think that concept that we have, that Jim laid the groundwork for us in those two cases, is huge. And I think that's going to be a huge thing for the state of Montana in the future. And it's just unlimited in the potential and the possibilities for protecting the public and the right of the people to enjoy and recreate on public trust lands.
I would like to, Jim, you have a brief comment. It's the role of the moderator. I know we have to stay somewhat close to our scope.
Up my sixth slide. When we won the Dearborn River case, when we won the Dearborn River case, I was very concerned about the takings issue. That is, whether there might be a due process taking of property because our stream beds were, by state law, down to the low water mark. And so I was curious because Kern had plenty of money, but I breathed a sigh of relief, much as I would have liked to argue another case in the U.S. Supreme Court, that they didn't take that up. And then later in Gulf, on the legislation, which I didn't handle, but they challenged on the takings issue, and that's in my outline. And our side prevailed on that. But then, much later, my firm filed the PPL case saying that the dams of PPL and the other companies were on state property, so the state could get rent. We tried to get Mike McGrath, who was then Attorney General, to take on the case because the state had standing. They wouldn't until we were partially successful, then they took it over. And then we were out, Judge Malloy kicked us out. But in any event, it went up to the U.S. Supreme Court, and much to my relief, it's the next, go to the next one. Next one, please. Going the wrong direction.
That was your last slide.
Okay, well, in any event, it's on page 11 of my handout from the DPONL case. And after the U.S. Supreme Court reversed the Montana Supreme Court on the streambed ownership issue because 17 miles of the Missouri-Wills Rapids are not navigable, they ended with a very nice, and I was worried about this takings issue, very nice long paragraph on public trust. And basically they say the public trust doctrine is of ancient origin, but most important they say the public trust doctrine remains a matter of state law. Huge victory for us, even though the state lost the case. Because Montana has a public trust doctrine, the U.S. Supreme Court has now stamped its approval. And I have to leave at noon, so.
Their biographies are in the materials that you got, so you can read more about them, but they are also the founding members of the new water law section of the state bar. Woohoo! So the water nerds are taking over the world, and they're going to sign their time in a way that we have questions at the end. So I will step out of the way and maintain Elias Pepper get started, and then Abigail Brown will move into the other content.
I'm not sure. Oh, this is working. So I kind of feel like Madonna wearing this. Do I look like her? Let me start by a little plug for the water law section, as long as I'm standing up here. So, we started the water law section of the State Bar in September, and we have some amazing things. So you probably should join. Like, if you're going to be a water lawyer in the state, we think we're providing some things for you that will help you in your practice. One of the most important things is a question and answer with the chief water judge. He obviously can't answer questions about particular cases, but we found it we've had one so far, and it's been very helpful in understanding some of the policies of the water court and being able to ask questions so he can sort of adjust some of the policies of the water court. We're hoping to have a Q&A with the DNRC, hoping to give our members opportunities to speak and to write so they can get their names out, and also give them opportunities to network with people who do lots of water law in order to be able to build up the number of people who practice water law. So that's my plug for the water law section. Maybe Abby might have more to tell you about the great things we do. But I'm going to start. I have not spoken at the law schools in about a dozen years. When I did my presentation on my senior writing project, And I can feel like I've come a long way. I was in the basement of the old library when I gave it, and my topic was something like the amendments to the McCain-Goldberg law and how it affects nonprofit law. And believe it or not, more than just Professor Burke and Professor Gagliardi came. I had two friends, my friend Sarah and Stephen Brucker, who some of you might know, he works for Trout Unlimited. They came also, and to this day, Stephen will still turn to me and say to me, 53 PowerPoint slides on nonprofit law. Hopefully it's helping him these days and understanding and how that all works. But I have really streamlined it. Today, my presentation is going to have 4 slides. Slide number 1. There we go. Slide number 2. So what I'm talking about is the ethics of advising landowners. And when I started thinking about this topic, the most important rule I thought that related to it was Rule 2.1, which is our roles as advisors, as attorneys. And as advisor, in representing a client, a lawyer shall exercise independent professional judgment and render candid advice. In rendering advice, a lawyer may refer not only to law, but other considerations such as moral, economic, social, political facts that may be relevant to the client's situation. I thought this was very relevant to the topic of stream access because there is a lot more than the law. So when you're advising a client. So I'm going to start with the first part, and that's about candor. Because when I think about the fact pattern that would go along with someone asking me to represent them as a landowner, I imagine that the typical fact pattern would be, I'm either going to buy a piece of land, or I have bought a piece of land, and I have an expectation that no one is going to be walking on this land. What is your advice? Or I'm having a problem because somebody is walking on your land. And how are you going to advise me? And I have to be candid in my advice. But what I really liked about it was the comments to the rules, which I just think they're brilliant. They say you have to give candid advice even if it is unpleasant to do so. You may do it in such a way that you sustain the client's morale, and you may put it in an acceptable form as honesty permits. But you have to do it in a manner that is that you have to do it no matter how unpalatable it is for the client. I just really liked how they put it. It's like I struggle with tact. So I'm really good at being candid, but I struggle with tact, and this can really help me. I need to be tactful in how I say it, even though I'm going to have to say it. People have a right, recreational have a right to come onto your property. But really, I just enjoyed that part of the rule. But really, I think the relevant part of the rule in terms of our discussion is the second part. And what it gets to is that it may be inadequate to just advise your clients as to the legal aspects of the law. And really you need, or the way it's worded here is that you may go further. You may tell them other stuff. But when I look at the comments further, I think as attorneys, we need to be aware that we actually may have a responsibility. That may be a shall. And the way we know that is the comments say, technical legal advice can sometimes be inadequate. It is proper for a lawyer to refer to relevant moral considerations, community norms, and neighborly relations. And there are 2 cases that talk about this responsibility. And one of the cases is out of the Northern District of Illinois in 1988. And in this case, the lawyer didn't advise the client as to investments, that a lawyer who was advising a trust was not advising their client that he should be investing the money. And he got in trouble. That is not legal advice. That is just simply advice of what a trust, norms of what a trust should do. And the lawyer got in trouble. This is branching beyond, so this is a shall. He should have given this client that advice. Another lawyer, and this is closer to home, was admonished because he didn't tell a client that an unnecessary easement might cause some family friction. And he was admonished for not doing that. So even though that's outside of the law, that he was admonished for that. And so when I think about advising a client who has a piece of property that they um, are struggling with how to deal with people coming on it, and what can they do? You know, and they can do some things. You could put up some signage, you could put up some fences. But we all know that doing certain things you can do, you may not want to do. And they may have some ramifications for you. And so you, as somebody who represents landowners, I need to tell them about those ramifications, or so the rule indicates. I need to tell them this is what your neighbors may think, or you should probably talk to your neighbors. The guy who's across the river from you, when he starts looking at your flashing sign that says no trespassing, you may be, impacting his quiet enjoyment of the river, and that might, have negative consequences to you. You might have the right to do that legally, but that might not be the best thing to achieve your goals. And one thing that the comments to the rule also talks about, and that I think is very relevant to stream access, is that you should be advising your clients to consult with other professionals. So when we think about this in terms of, I think about this in terms of advising someone on the Smith River, because there's a lot of, DFWP has so much interaction with that river. And that, I have a client, let's say, on the permitted portion of the Smith River, and that this new client really wants to shut down, like wants as much as he can to shut, to limit people's access in front of his property. And every day when people get on that river during the permitted season, someone from DFWP is probably interacting with them. And so probably I would consider advising that person, why don't you talk to DFWP? Why don't you get them? Maybe they could do something more effective for you than, trying to protect your property with fences and signs and all that. And they can educate recreationalists for you. Why don't you consult with DFWP and see in the past, what have other landowners done? Is there something that could be done just for this situation? So that's an important part in the rule, in the comments of the rule, that's included to direct your clients to consult with other professionals. And so that's probably what you should be doing if you're representing a landowner. Now, the comments had another really interesting aspect of it. A lot of the comments started talking about conflict of interest. And I think this could become very important because if you are being required to talk to your clients about other considerations such as moral, economic, social, and political facts, it gives more of an opportunity for your own personal bias to come in. And so I think conflict of interest becomes more relevant, and we really need to check in with that. Here comes slide number 3. So what we can't have, what is a conflict of interest is there's a direct conflict of interest. There's also the conflict of interest where there's a significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibility to another client, a former client, or a third person, or by a personal interest of the lawyer. And what is that personal interest? Like, personally, I own a raft. I float the Yellowstone probably 10 times a year. My family, that's one of our big activities. And so I have to check in with myself. Do I have, if someone comes to me and asks me a question regarding, as a landowner, what their rights are, and I'm advising them beyond just the law, but I'm also telling them the moral and political considerations, am I limited because of my personal bias? And, and the comments say, keeping in mind your own bias and making sure you give the advice in a manner which is protecting your client's interests, not your interests. And I tried to think about this, like, as a recreationalist, do I automatically have a conflict? And I back down from that I bet most defense lawyers don't believe murder is good. but that does not mean they have a personal conflict when it comes to representing somebody who has committed murder. It's more of, it's a more personalized interest than that. And I would say, so what is my, I have to check in of what is my personal interest. I know that there's a section of the Yellowstone that I floated by that had big no trespassing passing signs and so on and so forth. It was before you went into the natural channel, there are all these do not enter, no trespassing signs. And I find myself having a real, well, first of all, I'm trying to have a day off and I'm doing the legal analysis as to, is that a natural waterway, does it, can you go in there? What exactly did Mitchell Slough say? And, but, I had a very strong visceral reaction to that. If that landowner came to me, can I represent that landowner? Or does my personal reaction to what has already done, what I've already seen, does that conflict me out? Would I be able to be unbiased? And would I be able to represent his interests over my own initial reaction to that, what that landowner has done? So that is an interesting component of it. And as we all know as attorneys, is that we have a right, if we do feel like a conflict comes up, as long as it's in a non-adjudicatory setting, that we can choose not to represent that person. We can withdraw from the representation. So that's an important aspect of, if your personal interests start to trump the interest of the landowner you're representing, you can pull out from that representation. So that is what I have. Hopefully that took me. Slide number 4. Anybody have any questions? Yes. I hope you're not going to ask for legal advice.
We go down, we dock out, we lose them, and sometimes because on the river. And they get up, and of course, we just shoot them and they're going to land on private land. What is our right for retrieving that bird? Should we go with the least group commander, either gun in the boat, go get that bird, my lap out to get the bird? What is right, what is wrong? I mean, there's a question there of, the landowner might sit down and try to arrest me because I want the property, but I'm not going to waste the bird. That's the whole thing. There's no waste of the bird. You want to get it. Yeah, that happens a lot. I mean, there's nobody really can answer my question when I ask it. What's the right or what's the wrong?
That is a question I have never researched, so I could not answer it. But I bet if you hired an attorney and they researched it, they could. How was that? Was that very lawyerly of me? How did I do? You could tell Alps. That was my answer. Yes.
Would you add to what you have said with regard to your personal bias, the declaration of your client is important?
Can you explain that? I don't understand what you're...
For instance, a landowner comes into you and asks you about what are my rights with regard to the stream of my property. You have an obligation as an attorney to declare and tell him that, yes, I very strongly believe in the concept that the right of any person to come to the high water.
That is a great question. And sorry, the question is do as an attorney, if you are a strong believer in the public trust or the stream access law, do you have a duty to tell to inform your client if a landowner of that before representing them? And I think that's a great question and one I hadn't considered. Another aspect of I don't know whether it's Rule 1.7b but a continuation of the conflict of interest is, if you do have a conflict based on the significant risks, the representation will materially limit your responsibility to the client, is you can have a waiver of written consent, sent. So that's a great point, is that I think you would have to consider, if you are going to represent the person, like even my situation, I float the Yellowstone. If any landowner on the Yellowstone were to hire me and on a stream access issue, and I very much enjoy my stream access rights on the Yellowstone, would I have to inform that person and get written consent before representing them? I think well, okay.
Ron is going to.
Oh, Ron, like, go Ron, go Ron.
You need consent, you need written.
Yeah, and what Ron is saying, if you need consent, you need written consent. If I'm going to tell someone that I want them to give their consent, that's because if I think it's important enough, and I'm just talking, if I think it's important enough that I need to tell them, it's important enough that it falls underneath the rule, and they need to consent under the rule. And is it, Ron? Do you know if it's 1.7b? You might not. Any lawyers really? Yeah. Okay, Abby's going to cover that. So, can everyone wait? I know you're on the edge of your seat for these ethics. Are there any other questions?
You know, I have a comment on that. I would want my client to be apart just from my responsibility concerning a conflict of interest. I would tell my client how I felt, and I think I could convince my client that it would make me a more effective advocate for their role. And I think we saw that demonstrated by Ron Waterman today, that his ability to see and believe strongly in the goal of the stream access law, make him a much better advocate for the stockholders.
Right. And so you would say that it's, because I equate it like, I mean, where is the line? If you're representing, I'm really just like, this is just talking about it. If you're a defense attorney and you're representing somebody who killed somebody else, do you have to tell that person, I think killing somebody else is really wrong? Okay. You don't think it's a good answer? Okay. Oh, gee, because
that's legal, whereas my conviction is more moral, philosophical, social, political.
Right. Then illegal. Okay. Okay. And I also wonder where the line is. I mean, is the line like, that is the hard part of being an attorney, is where is the line? Like philosophically, I think it's great. Which is fun. I mean, right, when you're a water lawyer, it's like there's so much work. It's like, oh my gosh. That it's like, oh, I get another day off. But yeah, I think I would rather walk out the door on day one than 3 years from now get sued or be put in front of disciplinary counsel. So every day of the week, it's better to inform your clients and risk them walking away than it is not to inform them. Yeah. I mean, every day of the week. So but I would think that people, stream access on the Yellowstone is probably, especially my personal, that I experience it all throughout the summer. Merits disclosure. Yes.
So I am confused about this discussion.
Okay.
Because we're talking about stream access being the law, and so, you're talking about if a client comes in and wants to challenge that.
Well, I'm more saying that not challenge the law, but when they're asking what are my rights under this law. But on top of that, I have the obligation to talk to them about neighborly considerations, moral concerns, political. To me, that brings in another layer, that my bias is more likely to come in when I'm talking beyond that. And so being that there's an extra layer under 2.1 where I'm responsible to talk about the morals of it, the neighborly aspect of it, I think that has more of a risk that my personal bias is going to come in, and so more of a necessity to inform my client of that risk and to get written consent to represent them despite this potential bias. Does that make sense?
Well, I think if the rule says we're supposed to talk about those kinds of issues whenever we talk about a legal problem, I don't see where, if something is the law, and we're going to talk about the variety of ways of approaching that law, why that comes into being what my personal position is. Because it's not a political issue anymore, it really truly is a legal issue. There is stream access. So that's what I'm asking is what part are we?
Well, I'm talking about as a recreational user who uses this river in a recreational way, my bias may be more than others. Yeah.
Somebody comes in and says, there's a natural barrier and right on this stream, and in order to get around it, you're going to have to walk into my property. Now I want to put a sign there, and I don't want anybody to come across that property, or if they do, I want to be compensated. I don't think that's decided yet. I think at this point, that's an issue that may generally be a legitimate issue, and I think you ought to say, hey, I'm a strong believer in stream access, but I'll certainly represent you. That means that taking as much as I can do to support what is legal, I will.
What? Yeah? Oh, yeah. Hey, my name is Abby Brown, and I am also a water attorney here in Montana. And I'm talking about ethics from the perspective of advising recreationists. Yeah. This discussion that we've just been having is actually really relevant to what I'm going to talk about. In part because I primarily represent landowners. That is what I do as a water rights attorney for the most part. But when we talk about disclosure and personal bias, my husband is an outfitter, and he outfits on certain rivers. And I find that I feel better disclosing that to clients, especially if that is somewhere where he works regularly, because it may, and I will get into this a little bit later, it impacts how a client views your representation and your job as an attorney. So because I mostly represent landowners, I thought, given this topic, well, who is a recreationist? And I think it was interesting, it was brought up in a previous panel. This may be something we haven't decided and fully defined when we look at stream access and we look at other recreational laws and use of natural resource. Who are we talking about when we talk about recreationists? So this was just, well, it was colorful because it's lunch and everybody's eating, but also to get you thinking, who are you representing when you're representing a recreationist? I also have pictures because it's lunch. So when you think about the conversations you have as an attorney, you start out with, have I formed an attorney-client relationship? And I think about this in a few different ways. The first is the cocktail party advice, or in the boat ramp situation, since we're talking about stream access. Or I think about, for me, with my husband being an outfitter, when he says, hey, I was guiding on this river and there's a natural barrier and I wanted the portage around it. What do you think about that? And I'm like, how's he going to use my comments? You know, do I want to tell him? Are his other guides around? Like, who's going to take what I said and go file a lawsuit? And then they say, well, this attorney told me. So you have to be cognizant of that. Are you forming an attorney-client relationship? We all have the telephone calls or the emails where they say, clients call you or potential clients call you and say, I was floating this river, or I wanted to access at this certain bridge. I'm not sure if the road is a county road or not. There's a no trespass sign. Can I do it? You have to be careful when you're talking, and many of us, I think in Montana, are recreationists. And so we ourselves, as an attorney, hold a special obligation to make sure we're not forming, inadvertently, the attorney-client relationship.
And that's really the point of this slide. I'm going to get back to talking about organizations in a minute. And I think something that's come out throughout this today, especially as the attorneys have been speaking, is that attorneys wear many hats. We're advisors, we're advocates, and when you think about personal bias as Dana and others were just talking about, when you sign up to represent somebody, you've signed up to represent their interests to the best of your ability and within the law. And so that's why I think it's important to think about your duty of loyalty and your judgment, and can you do that effectively? So when you represent the individual recreationists, and this applies to organizations too, communication, I think, is key. Talking to your clients, explaining to them what the scope of the representation is. Part B, and these are paraphrased, so these are not the exact rules, because the rules the rules of professional conduct are very long, so I encourage you to read them. But Part B talks about a lawyer's representation does not necessarily endorse their client's political views, and we had that discussion here a little bit too. And I really enjoyed listening to the panel talk about working together in a lens of bipartisanship on this bill, and that people can come together and represent their clients to the best of their abilities, and that brings up other issues that might need to be discussed. So the comments to this rule are interesting when you talk about your attorney-client relationship, and the Part D, which says, I forget up there, that a lawyer cannot counsel a client to engage in conduct the lawyer knows is criminal or fraudulent, but may discuss legal consequences of proposed conduct and assist the client to make a good faith effort to determine the validity, scope, meaning, and application of the law. And so I think about that with stream access in terms of self-help. And we've heard numerous stories today from the panel, so I don't even have to come up with hypotheticals, which is great. Landowners running people's rafts off the road, putting up panels under a bridge that crosses your property. So what do you do as the attorney? What is your role? And the key here in the comments are talking about a distinction between giving your client the analysis. Here is the conduct you're suggesting to me you might do. Here are the actual real-world ramifications. Here are the legal consequences. That's different than aiding your client in committing a crime or aiding your client in doing something fraudulent. And so the law recognizes, and I believe this goes along with what Dana talked about with Rule 2.1, that we as lawyers have an ethical obligation to talk about more than just the black letter law. We have an obligation to talk about political consequences or social consequences. What are your neighbors going to think? This may make you really unpopular if you put up all these fences. If you're a recreationist, it may make you really unpopular on that stream if you start walking all over people's property to retrieve your ducks or elk or deer. I'm not a hunter, so those things I don't know about, but what does that mean? And so we, as lawyers, just have to keep in mind that it's more than just the black letter law. When your organization is a client, I think you have special obligations. And under the rules, a client, I defined constituent here for you because when I was reading this rule, I thought, well, who is your constituent? But I think it's important because a lot of recreationists, a lot of nonprofits, and there are probably folks out here who represent nonprofits and recreational groups, government agencies, those are considered organizations. You, as a lawyer, you have an ethical obligation to think about who is your client. And your client is the organization. Your client is not necessarily the officer or the shareholder, the director or the employee. And so you have to be clear when you're representing an organization, when you're speaking with members of that organization as to what your job is, who is your duty of loyalty to. Part B up there, when it talks about a lawyer must proceed as reasonably necessary, that goes in, For example, if you have members who are committing crimes, the lawyer and the officers ask you to look into that. You have an obligation to look into that on behalf of the organization, but you don't have an obligation and you actually cannot talk about that with the constituents. So you may interview them, talk to them, but you can't then say, hey, here's what I'm doing, because you are acting on behalf of that organization. So a lawyer's professional duty to an organization applies equally to unincorporated organizations, so we're not talking about just formal representations. And this goes back to the attorney-client discussion we had earlier, with making sure you know who is your client, making sure you know who can act on behalf of that organization, who can you get that information from, when does the confidentiality come into play. I think in part of stream access law, and if you're representing an organization on either side of stream access, the decisions about policy and the operations of the organization are not yours to make, it's the attorney. So that's something to keep in mind, that you are their advocate. They've hired you to follow their decision making, and I think we heard a lot of examples of that on the panel too. I think it was Senator Kirpin maybe talked about, he read the stream access law and he thought, hey, this is a good bill, but that's not who has employed me. That's not my job here as an attorney and an advocate. I have to represent my constituents to the best of my ability, which also ties in to what Dana was talking about with personal bias and conflict. And I have cited 2 ethics opinions. I won't go into them, but these duties also apply to agency attorneys in terms of who is your client. Is it, if you're a state of Montana attorney, is it just the agency? Is it the larger branch of government you work for? Is it the entire state of Montana? It's something to consider. So one of the things that I often think about when as a lawyer, and on this topic of stream access, is can I represent both landowners and recreationists on the same source? Is that a conflict? Can I do it on a source where I am representing them in the water court and we're talking about water rights adjudication? Maybe. Could I represent a landowner on an access issue and represent a recreationist on an access issue on that same source? I don't know. Could I represent in the water court landowners looking at water rights, irrigation water rights that are generally, you can think of that as a consumptive use? Could I also represent a group who was interested in in-stream flows? Would that be a conflict? And I think Stan talked a little bit about, we haven't answered all the questions around in-stream flows yet. So you have to look at these things when you're thinking and talking about the public trust. We brought that up earlier today. Is if I had a recreationist client who came to me on the Beaverhead and said, I want to talk about that, I want you to represent me in advocating for the public trust on the Beaverhead. I have a large number of clients down there because that basin is in active adjudication. Could I take that, or would I have a conflict of interest? So the rules are very helpful when you have to make these decisions. Rules 1.7 and 1.8 talk about conflicts of interest with current clients. And the representation of one client, if it's directly adverse to another client, which is kind of obvious. Though the comments have a lot of explanation about that, but I think it's obvious if you're on the other side of the same client, it's probably a bad idea. But the second part of it about, is there a significant risk that representation of one or more client will be materially limited by your responsibility to the other client? And in the comments, this talks, and I think it gets at our earlier conversation, that your first client may feel, you've betrayed me. You're representing somebody on the same source as a recreationist, and I've hired you to represent my interests as a landowner, as a water user. And that second client may think, the recreationist may think, well, how can you fully represent me as a recreationist where I want to fish, I want a lot of water, I want in-stream flow, and you're over there representing somebody else on water rights, and they've got giant pivots, and from my perspective as a recreationist, they're taking a bunch of water. Is it a direct conflict? Maybe not. Is it materially, am I materially limited? Maybe. There's also the perception of conflict. And so we look at the rules and the comments here. There's also some more conflict of interest rules if you're interested, but the rules go in, or the comments to the rules go into different situations in which a conflict may arise. And the comments to Rules 1.7 give a 4-step process for determining whether or not there's a conflict. The first is to clearly identify your client. Who are you representing? What are their interests? What is the scope of your representation? The second is to determine, is there a conflict? Does it exist? Are we directly adverse, or is there a significant risk of being materially limited? If there's a significant risk, can the client consent despite the conflict? And there are certain conflicts that are waivable, that you can get written conflict waivers for, and there are some conflicts that are not. In water law, we run into the conflict of interest that's waivable all the time because there's not enough water lawyers. This is a plug to have more water lawyers join the water law section to learn about water. There's not enough of us, and so if each one of us could only represent one client on a stream, we would never get through the adjudication, ever. And so we run into the idea of conflict in terms of waivable conflict all the time with different landowners. And then if you look at from a recreationist perspective, I may represent a lot of landowners on the Beaverhead with water rights, but perhaps somebody comes to me, a recreationist, and says, I have this one landowner and this one problem. It's an issue of portage on this one section. It's an issue of access. Could you represent me there? I would have to go through this analysis. I would have to disclose that my husband's an outfitter, though he doesn't guide down there, and disclose what else I do in terms of that part of the state. But that might not be a conflict as long as the scope is limited, because it's looking at one landowner, one portage route, one access issue. If it expands further into something regarding in-stream flows or the public trust, I'm not sure that conflict would be waivable, because I don't know that I could, when you look up here, the material limitation, I'm not sure I could advocate for both of those clients on that same source to the best of my ability, because it's one client is consuming water, one client wants more in-stream flow. So you have to look at each example and each situation differently, especially on issues like this, that yes, we have the stream access law, but there's so many other nuances that I think have not been addressed that I know will be talked about in the next panel. So that have been addressed, but hopefully they'll talk about what hasn't been addressed also. And if the conflict is waivable, then you get informed consent in writing. I think I was going to touch more on the personal interest conflict here. We talked about it a lot already, but I think what I would add for attorneys is you also have to look at what nonprofit boards do you serve on, or what other organizations are you a member of? Do you have any fiduciary duties to a different organization that could potentially conflict with your private practice representation? If you work for the state, does that conflict with organizations you might be a part of? If you're there are attorney legislators in here who can answer this question better than I do, but you have to look at that. What are your personal interests when you're a legislator, when you're lobbying? Does that conflict with how you're representing your clients? And so there's a lot of analysis that goes on behind the scenes, I would say, of when you decide who to take on as a client, especially when you look in the natural resources world, when you look in water rights. I mean, water is becoming, it's important, but we're seeing it more and more in the national spotlight, and here in Montana, and it's becoming a hot button issue, and there is more litigation. And so really thinking through, what could this representation look like all the way to the end? Because I agree with Dana, it's better on day one for that client to say, hey, you are not the right person for me, because here's what I'm telling you I need today, but my ultimate goal is public trust, and you're not going to get me there. I would rather refer them to somebody who can get them all the way to the end than to just take that one client for that one case. And I think as a small state and a small bar, that also does well for your reputation as an attorney. I heard a lot about Ron Waterman and Jim Getz and their reputation as people and attorneys on this panel, and I think that's important for attorneys to know. That's part of why, we're a self-governing body, so our group, so we have to follow these rules and enforce them amongst ourselves. Here are resources where you can find ethics opinions. And does anybody have any questions or comments?
For Ron, Tom read off this long list of organizations you represented. When you worked on the bill negotiation, how did you organize that so that you could communicate with all the clients and keep their interests in mind, stay on the right side of the ethical rules? So when I'm asking Ron, how did he organize his representation of 15 different organizations that were aligned on legislation? How did he communicate with the client and work with them when they need to make decisions?
So this was back in the, let's see, 33 years ago. So the nice thing is it's a kind of an as I remember answer. This is pre-internet, pre-email, pre-any instant communications, pre-cell phones, et cetera, et cetera. My memory is that we pulled all of those organizations together very early on and tried to identify if there were common areas of interest that they had all aligned together. I can remember having meetings with a broad variety of individuals. Not all of the groups joined at once, so subsequently I had separate meetings with executive directors or boards or members of boards from other organizations who wanted to become involved. So it was to identify, did we have a common set of issues to deal with, and whether or not there was conflict between any of those organizations. And on some of them, I think there was, and we just simply told them that they couldn't be part of the coalition, if you will. Communicating with them was relatively, well, it was relatively easy. I recognized the need to do that, and I asked that group to put together a steering committee, if you will. And I reported to the steering committee, and then use them to communicate back to the clients. But it was an ongoing matter of, I dealt primarily with individuals within the Stock Growers Association and Cattlemen's Association and the Farm Bureau, as I recall. And then that steering committee reported back to the membership as a whole as to where we were, what was going on, how we were going to mobilize, and things along those lines. Everybody talks about this seminal subcommittee meeting, and knowing that was, that started about 6 o'clock at night, and I think it broke up. Tom can probably recall as well as I do. I think it broke up about 10:30 or 11 o'clock at night. It took the entire evening. one way or another. But so we put out calls to make sure that everybody was there and the like. I did a lot of information of this was sort of proposed testimony. I circulated it around again through the steering committee and then got feedback from the client. It was a juggling act, especially because you have to ask the clients, all right, where's the major goals that we're moving toward, and then can you get their advice as to, you know, we talked a little bit about the lake issue. One way or another, lakes were in that legislation initially, but it became apparent that we were not going to pass that legislation if lakes stayed in the litigation or in the legislation. We had to take lakes out. And did we have, fortunately, we didn't have members who exclusively were there as a lake owner or property owner just simply around lakes and things along those lines. But had we had a lake owner association as part of that coalition, I think it would have been made much more difficult. We would have come to a conflict. But as it was, you know, we knew where we were and we took lakes out. We agreed among the coalition, among the other coalition, not my client coalition. You know, and that was the other thing. You're dealing with two coalitions. I had a coalition of clients, and I was dealing with a coalition of others. I hope that answered it.
Any other questions, comments, thoughts?
No, it's fine. This works out good. Yeah, I was just gonna ask a hypothetical question, and you know, what I've seen over the years is that the subdivisions want to put more and more wells along rivers like the Big Hole and so on and so forth. Who would win in court, or who would have the best chance in court on the water users? Because those subdivisions, they pump 30 gallons per minute, are depleting their water rights, or the recreationists who see dewatered streams as a negative impact on their fisheries. So, could you answer that?
I'm like, I heard wells.
We're hoping that the legislature and the agency will answer that question.
I have no comment on the answer to that question. You have picked a lot of, you know, I think that's what's so important about discussions, because exempt wells and their impact or non-impact, there's a lot of discussion on that issue, how it intersects with recreationist rights. There's how it intersects with surface owners' water rights. I mean, it's such a complicated topic that, and as we've talked about, this is an area that there's a lot of political views, and so I would hope the legislature would answer that, and I will defer to them. And Mark.
Well, this is an issue where recreationalists and the landowners be together on. Now, the state government has fumbled around with this issue of direct connection, and we don't know what the outcome will be, but it seems like things are getting drier, although we could have a good snowpack this year. This is going to come to a head. You know, water rights, which is your baby, and I was an old water commissioner on a tough stream. That's heavy duty stuff when the ground gets dry. And if it's getting drier and there's no water for the crops, that means there's no water for the fish. These two groups ought to get together. And you know what? I ought to hire Ron Waterman.
I was going to say, I think Ron talked about that.
That was a really good plug for the final panel, where we're going to have a non-lawyer talk about some of the drought science, and we're going to talk about tribal and water rights issues. So hang in there till the end. Okay, one last question.
How are you and Dana
So the question was, how do Dana and I handle disclosure of stream access laws to in transactions, either to buyers or sellers? You know, I think we're pretty, or I'm pretty. I think I can speak for Dana too. We're pretty candid about it. My law partner does a lot of transactions, and I do the water side of it, and I just try hard to give the bad news as easily as I can, because when you look at even the water adjudication, I mean, we're not final. I mean, especially when you're talking to out-of-state purchasers, I give them the law. I tell them what it is, both in water rights and stream access. I refer them to other resources and groups to learn more, but I give what I think is pretty full disclosure, and just this is what it is. And there is a lot of pushback from some folks, but there are also many who embrace it, and that's part of why they ended up here. But does that answer your question? All right. Thank you.